this morning's docket. Case number 106083, State v. James.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of Tommy James. I request 5 minutes for rebuttal.
5 minutes is granted.
Your Honor, this is the cell phone search case out of Franklin County. It was interesting to me as I was preparing for argument and reviewing the brief that we filed in April 2012, where we stated about the unsettled law of cell phone searches, which was the case in 2012. I think less so now, after the United States Supreme Court's decision this summer, which pretty convincingly held that under the Fourth Amendment search incident to arrest doctrine, that doctrine does not extend to the digital contents of a cell phone, which is exactly what happened in this case. The officer took Mr. James' cell phone incident to his arrest for transporting an opening container and proceeded to search it for text messages. So that seems squarely to me to fall under Riley.
Let me stop you there, counsel, and simply ask you whether or not we even get to the constitutional question. Why isn't this just purely a question of statute? And is counsel familiar with this court's recent decision in Julian?
Yes, Your Honor.
Does Julian apply here?
I certainly got this court's order, and I would say certainly the reasoning in Julian applies in this case. Yes, and certainly it's this court's tradition or precedent to avoid constitutional questions if it can. And so to that extent, yes. My only concern here is I have to admit I have not raised this on statutory grounds. And so I haven't raised it on statutory grounds to the extent that that's an impediment. It was certainly raised. The statute was cited in the motion in district court, and as was Gantt, which is sort of the basis for Henning and therefore Julian. So to that extent, it's not that it wasn't raised below, but...
Julian says the correct legal standard to review these kind of questions is to look at the statute first.
To look at the statute first. So, yes. I mean, after Julian, I thought, there again, I've not understood 22-2501 correctly. And had not raised it in that capacity. I had not foreseen Julian. But the answer to your question is, yeah, if you were applying Julian and the finding that subsection C was unconstitutional, this was a search incident to arrest. In fact, interestingly, after I got the court's order, I sort of looked back on it, and although the court's order only talked about the text messages, actually the district court's rationale for the search of even the glove box where the marijuana was found, it was justified as a search incident to arrest. So, although that wasn't the scope of the court's question.
And this particular search occurred during the time period, the same time period that Julian's discussing, basically between
June 2009 when Henning was decided.
And 2011.
And yeah, this was the December 2009 search.
Okay.
So we think certainly the rationale of the Court of Appeals in this case, Your Honor, was squarely rejected by Riley in the United States Supreme Court decision, and therefore, either under the statute or under the Fourth Amendment, the fruits of that search should be ordered suppressed. Your Honor, that affects not just the possession with intent to sell conviction in this case, but at least the drug-related cases, because Mr. James' defense in this case was, I didn't even know about it. In fact, the unusual circumstance in this case of actually having somebody else come and testify at trial under oath after being warned that they're essentially confessing to a crime, that it was somebody else's marijuana and that Mr. James didn't know anything about it. So his knowledge of the marijuana itself was really the contested issue in this case. And so these text messages didn't go just to his intent to sell, but even his knowledge of the marijuana and control of it. So we feel for those reasons that this court should reverse at least all of the drug-related convictions in this case. I don't have anything else, Your Honor.
Will you plan to go into more detail on why specifically this is not harmless, or are you going to stand on your brief?
Your Honor, I can speak. I mean, it's certainly referred to over and over, these text messages, and in fact, it's a critical part of the state's case with regard to intent to sell. It's not necessarily all of it, but it's certainly a critical part of it. And, Your Honor, I think it's a critical part of the state's case as it relates to whether Mr. James even knew about the marijuana in the glove box, because that was the really second part of this contested issue. So for both of those reasons, I don't know how this court could find beyond a reasonable doubt that this could have had no impact on the jury's verdict in any of the drug-related cases. That's all I have, Your Honor.
And which standard are we applying then on reversibility? 6261 or the constitutional standard?
I've raised this as a Fourth Amendment issue, so I'm arguing harmless error in the terms of the constitutional violation. If you reach it, I guess that's an interesting question. I hadn't thought about it from Justice Stegall's position here of, if you decided on the statute that it's to be excluded, does that moot the constitutional issue? Maybe not, depending on if the harmless error standard is different.
It doesn't transform a constitutional violation. It doesn't cure that simply because you have a stricter statute. I mean, it may violate the statute and not the Constitution, but if it violates the Constitution just because you have a stricter statute, that doesn't cure the fact you have a constitutional violation, does it?
It doesn't. No, it certainly doesn't cure it, no. And I guess I would end, Your Honor, saying under any harmless error standard, I think you would reverse. Again, this is the unusual cases I'm reading it, to actually have somebody else come in and testify under oath after having been warned that they're essentially confessing to a crime. This was my marijuana. Mr. James didn't know about it. And so I think even under any harmless error standard, you would reverse. But it's an interesting, and I hadn't thought about the interaction of the harmless error with the question of sort of how you decide it. That's certainly right. I suppose if you got to it and said, there's a statutory error, but we're finding it's not harmless under the statutory harmless error, then you would still have to get to the constitutional error.
You mean if we found it harmless under the statute, we'd still have to go to constitutional?
Yes, Your Honor.
Yeah, that's the only instance. Okay.
All right, any further presentation?
No, just clarifying for the sequence of events here, Mr. Hodgson, was that he was stopped. Was the cell phone searched prior to the finding of the scales or after? Because he acknowledged the scales were his, and he made some statement they were a hood ornament, but they were calibrated in a way that would suggest it was used for distribution. So was that prior to, or do you recall?
Yeah, I'll double check this as I sit down, Your Honor, but my recollection is that they found the bottle in the car, and he was immediately arrested at that point,
Right.
and that those things took place then. But I'll double check and see if I can find that answer while I'm sitting down.
Okay,
Your Honor.
thank you.
And am I remembering correctly that there's no argument for good faith exception on the state's part in this case?
No, there's no
Not
argument.
below or here? Yeah.
No.
Okay.
Any more questions? Thank you,
Thank
counsel.
you, Your Honor.
May it please the court, Your Honor. This appellee appears by James Ward, Deputy Franklin County Attorney. May I proceed?
You may.
Thank you. Your Honor, quite frankly, I have to right away let the court know that I see and completely appreciate that the state has two large hurdles in this case. First of all, the holding in Riley from the United States Supreme Court, holding that the search incident to arrest exception does not apply to text messages. And then finally, of course, after being brought to our attention from this court, the holding in State v. Julian this summer. Those are two very large struggles, and I can appreciate that for sure. The state's position, quite frankly, I think right now is that we're asking you to uphold the conviction. I would like to be able to argue a couple of things in light of the State v. Julian opinion that I've now been able to read. I did not brief either the Court of Appeals brief or the first appeal or the supplemental brief to this court as well, but I have had an opportunity to read those, and I've read the opinion after the court, this court directed us to for State v. Julian. And in State v. Julian, this court discussed briefly at the end of the at the end of the opinion whether or not a good faith exception might apply in this particular case. I would ask the court, quite frankly, to provide, at least consider that and give that an opportunity.
Aren't you too late for that now? And the reason I say that is not because of Riley or Julian, but really although Julian's sort of an extra step further than we've gone before, we have case law going back before I was even on this court that talks about the statute providing the scope of a search incident to arrest. I mean, I think Chief Justice McFarland wrote that Kahn opinion. So, it seems like if the state's certainly on notice from a long time ago that a good faith exception might apply, and didn't argue it at the district court level. So it seems unfair to be able to do it now. So how would you respond to that?
Well, quite frankly, Your Honor, I would ask that we are able to brief this supplementally. Obviously, this came to light for me when the court directed our attention to Julian, and Julian is pretty clear in its holding. At the end of it, it indicates that, just what you said, that the good faith exception probably would not apply in this case. My response to that, Judge, is quite simply that this same fairness that this court allowed in its understanding of when 2501C was found to be held unconstitutional, this court allowed the good faith exception to be applied to cases where the officers relied on that statute.
But only because the state raised the good faith issue.
Right.
And let me tell you why I don't think it's fair, and then you can argue against it on that.
I understand.
When the defendants were coming up and trying to fight the good faith exception, this court said, well, there was another argument out there, which is this statute and the permissible scope of the physical search, and you didn't raise that, so we're not going to consider it.
Right.
So, it just seems like, we're holding the defendant's feet to the fire, and I can't understand why we shouldn't hold the state's feet to the same fire.
And Justice Biles, I completely understand what you're saying. I do understand that point. I think, this particular case from its onset has always been focused around the constitutionality of the search incident to arrest for the text messages. That seemed to have been the whole battle. Why it wasn't briefed and argued, I think it was that everybody was really trying to stand on the merits of the case. Quite frankly, this court brought it to the state's attention through its order to look at Julian. And then, that's when I became aware of it. Of course, that was only a couple weeks ago, so it was too late then to brief. I would ask the court, quite simply, the fairness might be allowed if we can both brief this supplementally after the fact, because I think it's such an important question for law. The idea that Julian held that there was no search incident to arrest exception for just fruits and instrumentalities of a crime from 2006 to 2011. In this particular instance, this falls outside of where the court has been in allowing the good faith exception, but I still think the rationale was the same. The officers in the state of Kansas were relying on this, trying to figure out what the law was. I don't think they were operating in any gray area, and when this court in Henning struck down C, everybody assumed. I just think everybody assumed that the Warren exception for discovery of fruits and instrumentalities of a crime still applied, that we would just retroactively go back to the long-standing doctrine under the Constitution and all the cases under that progeny. And I think that was reasonable. I don't think the officer here or any other officer during this period of time would have acted any differently. And I think that the good faith exception is stooped in this idea that it's trying to deter future bad conduct by law enforcement. It just quite simply wasn't here, I don't think. I don't think that by excluding this evidence in this particular case, it would serve no other basis. It would serve no public interest. I don't
Counselor,
believe.
can I
Yes.
stop you there?
Yes,
Let's
Your
go
Honor.
back to fundamental.
Yes.
A search that is not supported by a warrant is per se a violation of the Fourth Amendment, correct?
Yes, yeah, absolutely, Your Honor. Yes.
There are certain recognized exceptions.
Yes, Your Honor.
And you, as the representative of the state, have to prove the exception to the per se presumed constitutional violation, correct?
Under the constitutional standard, absolutely, Your
And
Honor.
why wouldn't the state's obligation be to prove that the search did not violate either the Fourth Amendment or more restrictive state law by statute? Why wasn't that your obligation?
I think that it was our obligation. Your
Well,
Honor.
then if it was your obligation,
Yeah.
we get back to Justice Biles' question.
Mm-hmm.
The statutory question goes back to, I think it was Anderson was the
Yes.
Chief Justice McFarland that said, we don't care what the Fourth says, the statute says what it says, and we can be more restrictive than the Fourth.
Yes,
And so it was your obligation as the prosecutor to prove that this search didn't violate statutory law too.
And I agree, Justice Johnson. I believe, though.
And then, given that, if you
Yes, sir.
agree that you had that obligation, then the question is, way before this happened, how could you say, way before this happened, we had a case law that says this was not an appropriate search because the statute applied and you had to be in the presence, the way this, what Anderson said. And even though Belton was more liberal,
Right.
our Kansas law wasn't. So how do you get to good faith? Even though Belton was out there, how do you get to good faith when in this state for Kansas law enforcement officers?
I believe, Judge, that when Henning came out and this court struck down the subsection C, that nobody thought that there was no search incident to arrest exception for fruits and instrumentalities of a crime. I think that everybody still felt like that applied. And I guess my strongest argument would be, Your Honor, is that when the entire statute was repealed, all of 2501 was eventually repealed in 2011, we all assumed that we would immediately return back to constitutional standards for warrant exceptions, for exceptions to the warrant requirement, which is definitely that, per se it's unreasonable. But everybody assumed that when that statute was repealed, that we returned back to the law as it was before. And I think that that was a reasonable assumption, Your Honor, for law enforcement to make. In fact, I think most people were making that assumption
Counsel, what-
that when C was,
Sorry to interrupt you,
No
but
problem.
I understand your argument.
Yeah.
And taking that, even if you were able to establish a good faith exception
Right.
to the Julian standard,
Yes.
wouldn't you still be left with, defendant is arguing a constitutional violation. Wouldn't you still have to establish a good faith exception to Riley's holding also?
right. I believe
And
so.
couldn't you
and-
have raised that before you became aware of Julian? But the state never raised that.
Yeah, I think that, again, the merits of the case were simply, Your Honor, that there was so much case law out there indicating that what the law enforcement officer did at the time, I think it should have been briefed stronger, but I think it could be somewhat implied.
Well,
in
it
the
wasn't
sense-
briefed at all, was it?
You're right. I mean, it really wasn't. And that's absolutely fair, Your Honor. I don't want to be misleading. It was not briefed. But implied in that might be the idea that there was so much case law out there saying that you could search text messages. Basically, you could search cell phones incident to a lawful arrest, and that was a valid exception. That I think that was really where everybody was trying to go and was trying to get a ruling on the merits of the case. And the good faith exception, Your Honor, should have been I would again ask that this court allow me to supplementally brief that issue, because I think it's so important when we sit there, if we determine that during this period of time, there was no, we've already determined that there's no search incident to arrest, for instrumentalities, for discovery of fruits and instrumentalities of a crime. We've already established that through Julian, but I think that a good faith exception, being that as crazy as things were from 2006 to 2011, I think the officers were doing everything that they should have been doing. They were trying to follow the law. In fact, as soon as, Gantt came down and then Henning, everybody started changing how they did things immediately. And this court recognized, well, you were on this broad belt and where you were searching for any crime at all, completely inappropriate. In fact, the statute also, 2501C, is unconstitutional. But you found a good faith exception there. I don't know why we wouldn't allow this opportunity for a good faith exception here.
Okay, I think I understand your arguments on good faith. While you still have time left, I'd like to move you off good faith if I could for a minute.
Yes, I would like to.
And ask you this. One, at least theoretical way the state might be able to prevail here is if this search was consensual.
Exactly.
Is the state still asserting that it was a consensual search?
Yeah, and that's my only next argument, Your Honor.
Okay,
is
and
that
let me ask a few questions about that.
Yes, sir.
The defendant was handcuffed at the time the officer took the cell phone out of his pocket, right?
I believe so from the record. It was very clear, though, that he was under arrest for sure. And I believe he was probably...
And he was
restrained.
restrained.
Yes,
and he was surrounded by officers.
an officer. Yes, sir.
And so then I guess the obvious question to me just is, what is the evidence? How can the state claim that this defendant could have felt free to decline this officer's proposition to take his cell phone out of his pocket and search the cell phone? Is that your position? That the defendant could have felt free to decline the officer's request or terminate the encounter? And I'm taking language from this court's recent decision in Spagnola, which has very similar facts.
And I think what happened here, Your Honor, is that it's very case specific in this particular instance, that the defendant was Mirandized. He agreed to, he answered questions, and then he offered up the idea that the marijuana might be his brother's. So the officer, trying to figure out, whose marijuana this is, the defendant indicates that the number, he couldn't remember his brother's number, and so he offered the cell phone to the officer to try to corroborate the defendant's story. It wasn't as if the officer went into and grabbed the phone trying to search for additional evidence. That wasn't his original intent. His original intent was to either corroborate or disprove.
Except that the officer asked before he even pulled the phone out of the pocket about text messages. Clearly text messages were on the officer's mind.
Well, maybe I'm misunderstanding. Maybe I'm misremembering the record, Your Honor. That's a possibility, but I didn't try the case. I thought that he pulled the phone out, began to look for it, and then as soon as he did, the defendant changed his story a bit and said, well, I'm not sure it's my brother's. It is mine. I'll take the hit for it. And then with it already opened, is my understanding is he had the phone, and then he started looking for the text messages because there was no code or anything like that. So I think that's the stand. That's about the best I can do, is stand on the idea that the officer was into the phone originally through consent of the defendant.
Excuse me,
If there's
counsel.
consent.
I'm sorry. Who do I need to talk to? I'm sorry.
Just this.
Yes.
We have the evidence about what was said before he opened the phone or attempted to look into the phone about text messages, but also looking for a phone number and looking through text messages are two different activities, aren't they?
I think they were related enough, and I believe that the defendant probably, he was into the phone. I think he could have said, I don't want you looking at text messages. If you're going to go that much further, I'm narrowing that consent. I think that a reasonable person would do that if they knew there was evidence on there. I feel a reasonable person would tell the officer what they didn't want him to look at. It happens all the time. Sometimes we get consensual searches and then they'll say, well, I don't want you looking at certain pictures. There's certain things on the cell phone that I don't want you to have. And then, they narrow that scope all the time. So.
I have the
Yes, Your
same
Honor.
question, so
Oh, okay.
it's answered. Thank you.
Do I have any more time to
Could you clarify for me what the consent was given to specifically? Was it just to search the pocket and get the cell phone, or to search the cell phone for the text messages?
I believe he gave, the consent started, Your Honor, with the idea that he could get the cell phone, flip it open, and look for the brother's phone number, because they were discussing who owns the marijuana. And then as soon as that began to happen, the defendant indicated, well, no, he'll go ahead and take the hit for it. It is his. And so then I think it became a situation where the officer was going to continue to look, since he was in the phone, for which story was right and which was wrong. And because the defendant didn't say he didn't want to answer any more questions, and because he said it didn't narrow the scope of the search or cease the consent, I think the officer went ahead and continued to look.
There was not a finding by the district court that there was a consent given to search for the text messages. Is that correct?
I believe that the court used it as a part of the justification, but I think kind of like what we're here for today is everybody was really trying to focus this on, was this a valid search incident to lawful arrest? And I think the court found primarily, if you read which I'm sure you have, Your Honor, I don't mean to imply that you haven't, but the record indicates that the consent was a part of the discussion when the court made its finding that this was coming in, that these text messages came in.
The voluntariness of search is a question of fact. And so if there was no finding by the trial court that there was a consent given to search specifically for the text messages, what is our standard of review, since there was no finding?
Well, I think the court stated in there that there was consent. Like the court said there was consent
To look for the text messages?
I think it was to get into the phone. I don't think it went on that
That's the distinction
far.
I'm making.
Right. Yeah.
So we don't have a finding by the trial court that consent was given to look for text messages. Is that right?
Correct. It didn't go that far. And it only began at the very beginning of the opinion by the district court. It basically said, it gave some rationale, some background, and then it said, the defendant consented to allow the officer to look for this, and then the court immediately went into the rationale under the search incident to arrest. So it's kind of difficult, I think, to parse out, was consent also considered, or was it only a finding search incident to a lawful arrest exception?
All right, thank you. Any further questions?
I do, Chief.
Yes.
I think we were talking past each other perhaps. Let me just clarify. The portion of 222501 that allows or authorizes a law enforcement officer to reasonably search the person arrested and the area within such person's immediate presence. That's the scope of the search. That really wasn't changed by Gant or Henning, was it?
I think that the court struck down the entire subsection C.
Well, subsection C is whether you can discover the
Right.
crime or a crime. But what I'm saying is that someone cuffed and in the patrol car and searching the car, those two cases I'm talking about, Gant and then the following
Yes, sir.
follow-up on Henning, really didn't deal with that particular language.
The language that you just spoke about
Right.
earlier, the kind of like the physical scope
Exactly.
of the search. Yes, sir. And you're right. I mean, it didn't discuss that
And
except.
I think our question was that language has been in there,
well,
but pre-Henning and Gant,
right.
and we have case law that says the statute applies, it says what it says, regardless of what Fourth Amendment is. And so my question is, officers should have known by reading this statute before Gant the permissible scope, that they couldn't put someone in a car handcuffed
Right.
and then go search some other place that wasn't, quote, within such person's immediate presence, end quote.
Right. And Gant had that problem too. I mean, it was twofold. It was the idea that you can't search for any crime at all, but it also had to do with the fact that the individual was cuffed and in a patrol car.
And that was
so-
dealing with the Fourth Amendment.
Right.
And what I'm saying is we had a statute in Kansas
Right.
that our Supreme Court had said may or may not be more restrictive
Right.
than the Fourth Amendment, but that's okay because the statute says what it says.
Right. And Your Honor, I mean, the same reliance that the law enforcement had, that good faith, that the reliance that they had when subsection C was there, I think that you know, post Gantt, that those were still issues. But I think that, Your Honor, that the subsection C, when it was struck down, it does. I don't really want to argue to this court its holding in Julian as much as I do that the officer should have been able to reasonably rely on the idea that they could go back to well-settled Fourth Amendment law regarding when they're trying to search for
And
discoveries.
that's my
and-
question, Counselor.
Yes.
Why were they reasonably justified to act in good faith upon the Fourth Amendment when we have case law in Kansas that said the statute is more restrictive and the statute applies?
I think the statute still applied, but it was the same reason that we had to deal with it in Julian, and Julian wasn't. If that was the case, I don't think we would have needed Julian to talk and tell us that this was a problem. Julian held exactly what we're talking about here, but that wasn't done until several years later, and just not until just this summer have we even had this opportunity to even, I think, come to a realization that it's possible that there was no such incident to lawful arrest exception when trying to discover fruits and instrumentalities of a crime. I just don't think anybody thought that that was a reasonable assumption, that because C was struck down, and C, you know, there was that whole, when the legislature changed it from a crime to the crime, it seemed like Henning was all about the overbroadness of this legislature's change in light of the progeny of Belton and then Gantt, when the United States Supreme Court said enough. You've extended Belton too much. Everybody had this idea that this was surrounded around constitutional issues. And so when the court, I think you can read into Henning the idea that the court found, of course, that based upon Gantt, C was unconstitutional as amended by the legislature in 2006. Everybody assumed that there was still an exception for discovery of fruits and instrumentalities of a crime, even in light of C being struck down. And I think that the same rationale can be applied when, again, this whole statute was repealed and we never had an affirmative legislative act or an act of this court or any other court saying, okay, by the way, law enforcement, we're back to the constitutional warrant exception law. We're going back to that now. Because it's been repealed, we're now back to that. I think it's the same rationale. You strike down C, doesn't mean it was gone altogether, that particular warrant exception, but I just think that that's reasonable. I think it was reasonable for law enforcement when they're out there trying to figure out what they can and can't do. They've got law indicating that text messages are okay to search. I don't think it would deter any misconduct by police to give a good faith exception in this particular one. That's even if the exclusionary rule is appropriate, as Justice Malone stated in Vrabel, which was argued, I think, just a few days ago. I'm not even sure the exclusionary rule, I don't know if it even applies in a statutory construction, if that's the route we go. And I just think that with that consideration, with the consideration of what officers should and shouldn't be able to do in light of C being struck down, I think officers were acting in good faith. I do. I think they were trying to do what they were supposed to do.
By the same token, there's no reason under the facts of this case why the police officers looked inside that cell phone and didn't wait for a warrant. I mean, you agree you would have gotten a warrant to be able to look inside that for that digital information.
I would definitely agree that post Riley, Your Honor, there's no doubt I would be asking for a warrant. That's what we've been training our law enforcement on. At that particular time, I think everybody had been trained, at least in the state of Kansas, that so much law was out there that's saying that you could do this, that the search incident to arrest for text messages was allowable, that I don't think it ever even entered into the officer's mind to get a warrant at that time. Because it seemed fairly well settled, at least in most circuits, in fact, this circuit, that they could do that.
Isn't that also why, I mean, that argument cuts both ways, because it sounds to me like that's probably also why the officer didn't think that he had to obtain consent.
I think he wasn't too worried about asking additional questions about the consent, because I think he felt like search incident to arrest law was clear.
He
In
thought
fact,
he was
when
good without
testified-
consent.
Yeah, I think he was, because when he testified, I mean, that's in the record. I'm not going to go. I'm not going to try to put words in the officer's mouth. The officer clearly stated, "I felt I was justified also because of the search incident to arrest exception."
Well, that was the primary reason that the officer believed in his mind he was justified, and your argument today confirms that, right?
I agree. I agree. I mean, that's what was stated. But he did indicate at the record, at the suppression hearing, though, that he also felt he had consent as well. So,
Any more questions? Thank you, counsel.
thank you.
Counsel, were you intending to address the invitation by opposing counsel that we allow both sides supplemental briefing on this issue?
Yes, Your Honor.
All right, thank you.
First of all, I wanted to try to address Justice Rosen's question as I did sit down. As far as the order, I'm not sure the exact, but it's certainly the case that the investigation in this case was the stop, which there's no claim about, and then this investigation about an open container because they saw the bottle in the car and talked to Mr. James about that, and Mr. James made inculpatory statements about that. And he was placed under arrest for transporting an open container, is my understanding of the order. And then they went to search the car for evidence of transporting an open container. And that's when the marijuana was found. And the thing I couldn't find in my quick review is that when the scales were found? I assume yes.
Because they asked him about the scales.
And then they're confronting Mr. James with the marijuana when the issue about the text message comes up. So that's my understanding of the order in this case.
Thank you, Mr.
I don't know if that answers your question or not. On the good faith exception, Your Honor, first of all, it wasn't raised below, so I don't know what there is to brief about it at this point. And, Your Honor, there's a couple things about that. First of all, we have to remember this search took place in December 2009, after Gant, after Henning, after this court had struck down subsection C of that statute. And so it's sort of odd to think about relying on this statute that this court said had been struck down and had no legal effect.
But it's also after this Sylvan versus Briggs case from an unpublished opinion by the 10th Circuit. And I'm trying to figure out how that plays into some subsequent cases, the Davis case from the U.S. Supreme Court on where the good faith exception might apply. It's after the 10th Circuit's unpublished opinion. But after Davis, it still seems to me like if the state won, I'm making your argument for you, but it seems to me if the state was interested in a good faith exception argument, at least after Davis, you'd hold up your hand and say, how about that 10th Circuit case over here?
And, Your Honor, I would suggest, I don't even know how that's a particularly viable issue because, I mean, it's one thing to talk about good faith that I'm relying on a statute that has been upheld before or this long line of cases, but this is sort of where I started this case is there was not settled law on this issue of can you search cell phones, even as of 2012. And so this idea that, I mean, what the state's really asking you to do is say, until somebody says it's wrong, it can be in good faith. And that's not what the good faith exception has ever said. It said if you're relying on a warrant, we think that's presumptively okay. That's been expanded somewhat to say if, like in Davis, and where case after case has upheld these kind of searches, maybe that's good faith. This is, we don't have any idea whether we can search cell phones. Are they computers or are they more like containers? Give it a shot. Maybe it'll be up. In any case, even if you're wrong, it won't matter. That's what the state's arguing for. We don't think that needs additional briefing. I don't think there's any support for that theory. The last point on consent, I just wanted to point to the record on this. This is record volume 7. This is cross-examination of Deputy Voigt in this case. Asking, this is page 32, first of all asking, did you even look for phone numbers? And he says, I don't I don't remember. I don't recall if I did or not. I think I did. You don't recall? I don't recall. You immediately went to the text messages, it sounds like. Fair to say? Could have been. I don't recall that, whether I looked for the phone numbers first, but I know we had a conversation about the text messages. But he never authorized you to look at the text messages, did he? That's correct. He never did. That's correct. The judge's ruling on this, Your Honor, was, this is record 8, volume 8, page 4. He consented, Mr. James consented to Voight's looking at the cell phone for that telephone number. That's the most consent was in this case. And the officer says, I don't even know if I ever did that. I went right to text messages. It's an interesting concept, Your Honor, that I think if Mr. Ward and I walked out of the courthouse here and I walked down and I found out I had a flat tire and I needed to get some help, I didn't have my phone with me, I said, Mr. Ward, would you let me use your phone so I can call AAA? And Mr. Ward, being the nice person he is, says, sure, use my phone. And suddenly he sees me perusing his emails and text messages on there. I think he might think that I exceeded the consent that he had given me. There's no consent in this case. There was no finding of consent in this case. We would ask you to reverse all the drug-related convictions in this case, Your Honor.
Thank you. Any further questions? Thank you both for your arguments this morning. Court will take this matter under advisement.